your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything look smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show. And I want to welcome all the new subscribers to this channel. Welcome, and I hope that you are actually enjoying this content that I'm putting out on this channel. And as a reminder, if you guys really like the content that's on this channel, please do me a big, huge favor and subscribe to this channel and help this channel grow. Hey, EMS. Today is Judge Stephanie Boyd. My foot's hurting me. Let's get this thing started. Share screen. Go back here and make this bigger. I am here. I'm just muting my mic and I'm watching for ads. So I am here because any music and ads has been getting this channel struck. So I am here.
All right, everyone, I'm going to call the docket. When I call the docket, please let me know you are here. Shelby Rodriguez. Robert Marino is custody. Roger Talamontes. Roger Talamontes.
You're going to be on Zoom, Jeff?
Yes, I'm waiting for him to zoom in.
Oh, okay.
All right, we'll wait for attorneys to arrive. A jury panel will be up here no later than 10:30. And Norma, if you could call down, I know I said maybe 10:30, but if they have a jury panel ready before 10:30, they can bring them up.
And you want to have it?
No, based upon the charge, probably a panel of 65 will be fine. The docket.
Okay, awesome. Thank you so much. I don't know. He's always waiting. I put him there.
All right, thank you.
So you don't need that. That's enough. He's right. Oh, that's what I was talking to. Yeah, he's actually okay. Okay, well, let me see. Oh.
Well, it's October 1st. Today is Breast Cancer Awareness Month. Everybody needs to go get their testing done. You know what I discovered? When I didn't have health insurance, you could go for breast cancer awareness and they would only charge you, I think it was $15 or something, which even back in the day for me, that was a lot. But now I believe you can get them for free. And they have those scans too, where they do the hand scans where you're not smashed.
That's the one that you put here.
Yes.
Yeah.
I'm gonna have to do more research on that to see how great that is. But back in the day, it was very painful. Yes. To get that test done. But today it's not painful at all and it takes 5 minutes. And I have to remind my brothers and men, you too could get breast cancer. You too need to get scanned. All right, deputy is like, yeah, but have you gotten your scan?
I have not.
All right, so you need to do that. It's Breast Cancer Awareness Month.
I'm wearing the pink print right now.
I appreciate it. So when are you going to get your scan done? It's going to be this month?
I'm really very sorry.
Oh, all right, so we're going to make it happen this month. Everybody, Norma,
Yes, ma'am.
that's the goal we have in this court. Everybody in this court is going to have it done. If they haven't already had it done, we're going to get it done this month.
Okay.
I did mine this year.
It said that we'd be back in November.
Hmm?
I just got an email or something saying it would be back here in November.
Well, 'cause that's when I was gonna do it.
That's the first time?
No, I'm sure there's more, but not, I mean, I think in the
I
building.
didn't have any
Let me see.
history in my family, and there were no concerns. I didn't go until I.
All right, power to that doctor, but yeah, no. I want to say the first time
I mean, they've
I
been
had
doing-
one, I think I was probably 18.
Oh,
And it was because one, I was going off to college and they had certain, I don't know if they still do that now, but you had to have full medical thing and everything. And then we have issues in my family with that. So oh yeah.
Which I didn't know when I was good at it. I learned that the density ratings
Mhm.
matters.
oh, yeah,
I didn't know that.
yes.
So if you have a more dense, if you have more dense tissue.
Yeah.
Then she may not be able to tell
Mhm.
if you have any abnormalities. So you have to figure out what your.
I'm very distracted by the
know.
When you get out.
Mhm.
I didn't know that.
Going to.
I'm telling you, the testing that the ladies have to do, they should come out with something different. You know, I want to say, I think it's in Korea where you go in once a year for your testing and they do full body everything. And it's all in one building, one-stop shopping. Yes. And they do your blood work. They do everything. And they tell you what the issues are. They'll tell you, hey, you need to put the sugar down. So. Mhm. And they do the eye exam.
They're going to be in Commissioners Court October 9th and 10th.
Okay.
And then the HR training room, November 12th and 13th.
So they'll be in Commissioners Court October 9th and 10th?
Yeah.
Oh, people can sign.
I did that one, Judge, earlier this year,
Mhm.
and she was it was very relaxing where they had it at. But she had her scanner warmed up, her gel warmed up, blankets were warm.
Mhm.
So it was very quiet, musical, and she was explaining every detail what she was doing.
Oh,
I thought it was very nice.
okay, awesome.
For that stuff or something, I just kind of. Because I like everything. For average one, it's like the Susan bed and like. Whenever I was looking at my well, what's the stuff that we used to make sense? It's black. Truly wrong. And sometimes I think there's an ingredient that's in some of those medications.
Yes.
I'm thinking of boil it down. What are you so much bravery to add?
All right, are you Mr. Talamontes?
Yes, ma'am.
All right, what I'm going to do, your attorney is here. He is conferring with the state. And then once he confers with the state, I will have him zoom in so he can go to a breakout room and speak with you, okay?
Okay. Thank you.
So just be patient.
Yes, ma'am.
Thank you.
God, I'm ready to speak.
Oh, well, if you'll get with Miss Ferguson and she'll give you the Zoom link and you can join your client in room 1. The Zoom link.
Already get nice, no matter how much medicine I take, I'm gonna wake up. If I sleep, but I'll wake up, get a little relaxing, and then like rest my eyes for like 20 minutes and talk. But whenever I sleep with that, it takes over my whole head. But it's like, no matter what that I take, if I go to sleep with that, but
Day is young and I'm already running out of space.
Mhm.
Okay.
Also too, what I'll do is I'll put technical. Like sleeping. I mean, it's already 2 p.m. It's already 2 p.m. stuff, but it's like sleeping. Yeah. Whatever, and it's like getting that all week. And it's just like a.
All right, guys.
Yes, Your Honor.
We are all doing the 4th annual Harvest Trot, the 5K, put on by Rebecca Clay Forrest, the Commissioner of Precinct 1. It is October 12th. It is you need to be there at 7:30 to get your t-shirt. 7:30. And this is San Antonio. It gets hotter. And all you need to do is bring a non-perishable food group.
I'm gonna send my, non-version title with y'all. I'm gonna pull up 10.
I remember one day, they started doing this thing where you can race virtually. I'm like, what is this nonsense, racing virtually? So you're not really at the event racing. You just paid money to sort of be on the computer.
Yes, violence, but they have a sleep-in option. So last year I was in violence as a prosecutor, and I was like, I'm not gonna give them to prosecutor anymore, but I'm still going to do the awareness law. I made that promise to myself, and then I was like, I'm gonna actually do it because they have a sleep-in option, and then I signed up for like the walk, and then about yesterday I was like, I should have just signed up for the sleep-in option, and because we don't feel like the walk more.
Yeah. No. Yeah.
Yeah, but I will be there.
Okay, awesome.
Yeah.
Well, I will be there at the Purple Run. Yes, I'm always there. I sit at the table, I go do my walk. I struggle to find parking space because I get there at the last minute. And then I say, can I put like something in my window and double park? But I don't do it because I always have this fear that my vehicle is going to be towed. Sometimes they would say, no, the building is not open for business. It's closed. I said, do you see that sign that says violators will be towed? I just have this fear. You come out, and I always think if you come out and your car is gone, who do you call? Do you just automatically think, oh, let me call the towing company? I don't know.
There's signs that they say call this number.
Yes, Miss?
Yes, I want to know if it's, Docket.
Yes, she's coming.
Okay.
All right. Thank you. Sure. Yes, you may wait outside. You're welcome. But so we shall see.
Maybe just get there really, really early. Still, because we have our office meeting, so everybody else is there really early. And then I took cramping a lot. Well, I really forced myself to go on, but
Michael DeLeon will be there. He said he always gets a table, so he'll be there with his table. And then you try to get there, you try to do the right thing as far as being healthy. Then everybody has candy everywhere. You want some candy?
last year they gave out I'm going to brunch after this, but
The taco is looking good.
yeah.
All right, so is Brent Hardy zooming in?
Come to the witness room so we can talk to his client.
All right, we'll see if he zooms in. He has yet to zoom in.
I made, well, on a Wednesday at 4:30.
All right.
Yes, I will be healing in October. I won't be able to go.
Well, my mind is a steel trap, so I will remember that date.
Okay.
I cannot believe we're so close to 2026.
Why? When you said today, October conference.
Mm-hmm. And I'm
Like,
How many trials did you do this year?
I think it's 18.
Now look at that. She says she's only done 18 trials. We're slacking.
Well, basically, did you one without days? We had a lot of our trials lasted.
Yeah.
2+ weeks.
Yeah. Well, it was funny because we had Daniel Escobar in here and he got promoted. And how many trials did he discover he had done?
I forgot. It was a lot.
Like 30 or something. We're like, hey, come to the 187 where you will not get any trials. Okay, they say they have just seized $7.3 billion in crypto.
This thing, okay.
And I could say I have $1,000 every single week.
Yeah.
Like, I don't know what it's gonna
It may all be so fun.
Yeah. But I. Probably don't. Dollar.
Oh man, an ambassador from South Africa, his wife reported him missing, and he fell from, in Paris, 22 floors.
Yeah. Oh.
Get that space back.
That big.
I was on his way, he's just leaving Jordan.
You should.
All right, and can you check on Christine McDonald?
Okay. She's actually working from home. She has a doctor's appointment this morning. It was just that she didn't have any banana.
All right, could you then have somebody from mental health court come?
Do you know what her name is? Oh, Liz.
Hello.
But let me call Liz and I'll tell her. Oh. You are.
Oh. Okay, that's just the notes. That's great. That's all.
Well, they went up there.
Deputy Laura, how long before you finish with your book?
Oh, Judge, that small one is gonna be really fast, but it does have trigger warnings.
All right, so what's the name of it again?
No one writes for free.
He's on the field. Yeah, he had juvenile court this morning. Disregard, you know. It's just one. Are you looking it up, Judge?
Yes, I want to see what it's about.
Find the judge.
Not yet. I'm looking for it. But I am still, lately I've been looking at the Marlowe Murder Club. And Norma, has the jury already been called up? All right, thank you. Hello.
It's not Hollywood, did you see her? I don't know what she looks like. Like a white. That's not what girl. It's green. No.
All right, Mr. Hardy. Have you conferred with the state?
I have, Judge, and I still need to confer with them very briefly.
All right, okay.
Right.
You're welcome. Mr. Talamantes, just give us a moment. Your attorney is conferring with the state.
Yes, Judge.
Yes, Judge.
Were you able to find her?
Alternate.
All right, let me walk out. I'll go out.
Wait.
The deputy's got to make it happen.
The Judge, can you send me back to the break?
Yes, if you'll log back in, I'll send you back in.
Oh, okay. Thank you.
You're welcome. Mr. Talamantes, if you'll go back to breakout room number 1, please.
Yes, Judge. Thank you.
Thank you.
You left. She's lost.
All right, thank you. Yeah, yeah, I need to correct things on here. Yeah.
Possible trial. Possible, we don't forget it.
Judge Sarge came in here.
Hello. Hi, how's it going?
Good.
Welcome. Is there a reason for the visit? Are you here to give the deputies pay raises?
Oh, that's not up to me. I wish you would.
All right. Because, pay raises,
Sorry.
pay raises would be nice for them
Oh, I
and needed for what they do. Okay.
agree. I guess we'll find out soon.
Mhm.
All right, can I see you?
It should be Google.
No.
Wait.
I'm walking into something. I'm walking into
I'm sorry? Who is he?
We're trying to find out right now.
All right, just give us a moment, okay? Are you ready?
Judge, we are.
All right. I'm just waiting for Odyssey to open.
Now, can you, from your station, can you, like when the feedback started, can you shut me down or anybody
Oh, I
else?
just put you out of the room.
Oh, I see.
Yes.
That's pretty neat.
All right. So where are you on discovery in this case? And what are we looking at?
Judge, oddly enough, I think I've received, well, I feel quite confident that I've received all available discovery.
Mhm.
The problem in this case involves my review of the discovery. The defendant and I discussed, we discussed something that was mentioned during discovery. I did not hear it. It pertains to probable cause. I want to review that discovery again, but that's something I can do literally overnight, if not faster.
All right. And has an offer been tendered?
Yes, sir.
And sir, how old are you?
I'm 24 years old, Judge.
All right, Ms. Ferguson, I need a 3-week reset for plea deadline. All right, we're bringing you back on October 23rd. At that time, you need to be in court, Mr. Talamantes.
Yes, Judge.
All right, and thank you for dressing appropriately for Zoom. Have a great rest of your day.
You as well. Thank you, Judge.
Thank you.
Thank you, Judge.
Thank
May I
you.
be excused?
Yes.
Thanks so much. Listen, I'm sorry about screwing things up for you all yesterday.
Hmm.
It's,
No, I'm sorry to hear about that.
it's just well,
Yeah.
it's like a split sense of relief because we just walk up to the door and step back. And after a while, you get exhausted.
Yeah.
Anyway,
All right. Have a good one. I'll keep you in my prayers.
thank you so much, Jeff.
You're welcome. Do you all have anyone left? All right. And who has, and Shelby Rodriguez, that's family violence.
Yes, sir.
And then you all, yes.
Thank you.
Not talking, see that shit.
What earth, wind and fire is going on? Does I need to go over, you have me back here
Yes.
and,
Oh, they'll bring your client out.
well, I'm glad to hear that, except that it said it's
Sorry.
on Zoom,
They'll-
so I-
Yeah, they'll bring him into Zoom.
Okay. Oh, could I run over for 10 o'clock with a doctor on, Judge Lisa Rodriguez's book?
Just 1 second.
Okay,
See if they have this.
sure.
All right, thank you.
I just, kind of need to go back and meet him again. I gave a counter, we got all our discovery done, basically. I gave a counter offering to White. I didn't see him yesterday. He was busy. I was here with you on another case and this one. And I think Mr. Wright, who I gave him discovery regarding my client's medical condition, I think he was gonna kind of go upstairs and see if, they could treat it a little different than, because he has MS and various things wrong with it.
All right, so you,
I had doctor's stuff to say.
okay, yeah, talk to Norman and see when he can zoom in. Megan, before I'm gonna start doing this when people ask to leave. You've got to answer a riddle before you're excused, and it has to be correct. So here's the riddle. What demands an answer, but asks no question?
Not really. I really need to know.
So after y'all answer that, then you can leave.
Can I phone a friend? Hey,
You know,
No.
Hold on, what was the question again? What was the riddle?
What demands an answer, but asks no question?
well, I don't know. I need to find out from Jeff.
Well, I guess I'll go to my. We're gonna be ordering lunch in the courtroom.
Okay. Family violence, you want to help
I
criminal?
would have never known, though, Judge. I would have never known.
That's good.
No, but I like that you said that, but the answer is no.
That's all I had.
Yeah. So when we go home to go to sleep and y'all are still here, think about it.
Yeah.
This reminds me of the time people are left in the holding area overnight. Remember those days? Judge, I'm gonna, if it's okay, try to,
Cheating now. No. No.
I guess,
The most common answer is what Ashley said.
let me try the 13th
Okay.
so I can figure out what the the counters are on with Mr. Wright. Because I
Okay.
think he had to go upstairs because of the special.
Doorbell.
Okay, thank you.
You can add, you know, what are you guys gonna do? You can't leave.
I don't know where she's at. She's off today.
A rhetorical question.
No, I like that, but no.
A riddle.
Like that, but no.
The Joker. I don't know the Riddler.
Think.
Is it obvious? Am I gonna be?
It is so
super
obvious.
upset? Knock. A door.
No,
A door demands an answer.
no. And it's already,
A punch.
and so you know, here's what's so hilarious about it.
Yeah.
Adriana, you know what's so hilarious about it?
I know, because everybody has one.
Yeah,
Yeah.
and because they're doing
I
it.
know, that's what I was laughing at.
We're doing
We're doing it?
Your mind.
Just let him go, Judge.
Oh, I see no.
All right, I'll give you a clue.
A question.
Let me give you a clue. What's a song that was sung by Beyonce and Lady Gaga?
Telephone. Oh, that was the answer?
Yes. They got that one, Judge. They didn't get that.
I said it's on ringing.
Yeah,
Oh.
it's telephone.
What, so what are we doing right now? Well, we were.
You're holding your
Oh,
phone.
we were on our phones, okay.
Looking for answers, and I'm like, so yeah, but I love the riddle games.
I'm gonna have to study it. Yeah.
Okay, so all right, I'm gonna give you guys an easy one because I've started playing this riddle game. And you know what the thing about it, the riddle game that I'm playing is supposed to be for children. So, all right, here we go. Let me see. I'm going to go for medium. I make a loud sound when I'm changing. When I do change, I get bigger but weigh less. What am I?
You said that was easier, Judge?
Yeah.
It's a butterfly.
Yeah.
No. You're like, I have it.
Okay, the answer to that one was popcorn.
Oh.
Okay, so here's one. 3 simple words, but life changing. What are they?
What was the first one?
3 simple words, but life changing. What are they? Think Stevie Wonder. These 3 words. Yeah. That's what I was.
I was gonna say I love you, but I was like, it can't be that.
Yeah, it was that easy.
You won lottery.
Yeah.
Right.
Yeah, I like you won the lottery.
You want the, but you gotta get rid of the.
The,
You won
yeah.
lottery. You're the
Yeah.
winner. Yeah. I was like, you are hired.
Yeah,
You are fired.
All right.
You are guilty.
yeah. You can see me in water, but I never get wet. What am I? Yeah, it's reflection. Adriana is like, I'm making it happen. Did I get to go home early? Yeah, it was a reflection.
A reflection.
What is
You know, I don't think I'm very well until I sit.
Yeah.
Oh, yeah. No, you guys gonna start getting the riddles, because what building has the most stories?
The library.
Yeah. Look at you, Rick.
I was gonna say the courthouse. Courthouse
We have a lot.
we have a lot of stories. We have a lot of stories.
Okay, so this is the type of riddle I do not like, and I always do poorly at it. A man in a car saw a golden door, a silver door, and a bronze door. What door did he open first?
The car door.
Yes. Who's bringing it over here? You're rocking it, Ashley. If your uncle's sister is not your aunt, what relation is she to you?
Mother?
Your mom.
Your mother.
Yeah, look, and she still was like, wait a minute, I want to say it, but I don't know.
Melissa, have you answered any of them?
Yes, she said, I love you.
Okay. Your aunt said you are.
I'm the beginning of the end and the end of time and space. I am essential to creation and I surround every place. What am I?
Oxygen.
The atmosphere.
Air.
No.
Hydrogen.
O2. Oh, wait, oxygen.
I was gonna say matter.
Listen closely. I am the beginning of the end and the end of time and space. I am essential to creation and I surround every place. What am I?
Oh,
The beginning.
The atmosphere is God.
I scared that. Yeah.
God?
Sorry.
No?
Water.
I'm the beginning of the end
And he is in the.
and the end of time and space.
No.
I am essential to creation and I surround every place. What am I?
Water first. Water.
Matter?
Listen closely. Hey, Deputy Laura, I want y'all to internalize what I'm saying. I am the beginning of the end and the end of time and space. I am essential to
E.
creation.
The letter E. Oh.
Yes. There we go.
Oh.
Because it's the end of time
The end of time.
and space.
Yes, essential to creation.
Do not make a TA riddle team.
So you guys are going to be ready for tomorrow.
I pick up.
Sleep every day. Like my brain is warmed up to work for the day.
Yeah.
That'll be it.
Exactly.
Yeah.
Bye. For good night.
All right, bye. You guys have a good one. See you tomorrow.
Bye, Dennis. You're great.
Not at all. Patrol.
Not even there.
Not even
We take the patrol. Oh, so funny. I'm seeing our favorite friend.
All right. So how long before our jury comes up? Probably about 10:30.
About 10, between 10:15 and 10:30.
Okay.
So it's gonna happen? All right. Let's do this. You said 65.
Mm-hmm. Oh, she's here. Hello.
Hi, Judge.
How's it going?
Good, good.
All right, say that side. Thank you.
Want me to tell him anything?
Just to wait and we'll bring them in as soon as possible.
Oh, so good. Yeah. There's that money.
There, time.
I don't think they have one. See if that one.
It'd be great.
That'd be six.
Oh, you okay?
That was a cough and that was a sneeze.
Okay, so, her name's Amanda Winter.
Okay. So they petitioned to terminate Jordan's rights.
He's supposed to.
We did, we had the modification final trial with Brandon, he pushed it
It's not back here.
and,
It's supposed to, yeah.
wanted all these attorney's fees and all like a permanent injunction, which I did disagree with, because like, what if things change? We're still waiting for the appeal, blah, blah, blah. And then he got served the petition to terminate. And they hired me on that. I'm like, I think that ship has sailed no matter what happens, so.
Have you talked to Jordan?
Yeah. So, I mean, I talked to him.
Is he in the prison?
Uh-huh. Yeah,
Is he doing okay?
he's doing okay. He's a tablet and football season started and he's doing better, but it's cooling off. He was in a place that had he was in a place no AC.
Oh. It's the word.
What's the word, Amy?
No, she said she doesn't.
Can she do her case with me?
But that ring of anything.
I know.
You want to talk to her again?
Yeah.
Okay.
I'm gonna go to the backside. I need to fill my water bottle. Yeah. But she has a problem. Okay, over here. Sit on the. They're all the same.
All right, could somebody grab Cindy, please? The court reporter.
Um,
All right, are they already in line?
I don't know.
I don't-
Maybe it's 2:30. That's what I truly don't know. That's the problem. And also the stuff that says. I know.
All right, the court is going to call 2024 CR 009126 State versus Shelby Jean Rodriguez. Can I have parties announced?
And state of Texas.
I'll go ahead and APL, Shelby Rodriguez.
All right, and are you Shelby Rodriguez?
Donna.
All right, are parties ready to proceed? All right, let's bring the jurors in. If you could let the deputy know to bring the jurors in, please.
Oh.
I'm just letting you know. The mole. Okay.
The mole. Thank you.
Did you need something, counsel?
No, ma'am, I'm just getting my.
I mean, Mick.
Well, we're gonna drop this off in Melissa, but
Start, please.
Right.
Yes, please. Thank you. All right, ladies and gentlemen, you are in the 187 District Court. It is on the 4th floor and you are here with Judge Boyd. So what floor are we on? What's the court number?
7.
Who's the judge? And you're probably asking yourself, why is she asking us this? We know where we are. We know what floor we're on. The reason why I asked you that question is because whenever we take a break, y'all must leave the courtroom. You can't stay in here. And we've had jury trials before where we've taken a break. And when we take a break, what ends up happening is someone ends up getting lost. They'll say, I looked up, everybody was gone. So if you look up and everybody is gone, if you remember the 187th, people will be able to tell where you are because there is only one 187 District Court in all of Texas. 187 just signifies this was the 187th court created. So even if for some reason you find yourself in another county, which you should not be while we're in the middle of jury, if you say, I'm looking for the 187th, they will be able to tell you it is in Bexar County. And if you don't remember that, if you remember the last name Boyd, I'm the only Boyd in the courthouse. So if you just mention my last name, people will be able to direct you where to go. So this case is the state of Texas versus Shelby Jean Rodriguez. And I'm gonna have the state introduce themselves.
Morning, everyone. My name is Rick Bain.
I'm Ashley Jones, we represent the state.
And for the defense,
Good morning, everyone. My name is Adam LaHood. And this is Miss Amy Owen.
Hi.
We represent Shelby Rodriguez.
All right. And Ms. Rodriguez, would you like to introduce yourself?
Hello, my name is Shelby Rodriguez.
All right, everyone, you may be seated. Now, to my left is the court reporter. How many people here want to make the court reporter's job easier? All right. Thank you. Look, she's like, I don't know if I want to make the job easier or not. Let me ask it this way. Raise your hand, well, raise your cards if you want the court reporter's job to be more difficult. See? All right. So nobody, your answer is no, number 9. All right. So here's the way we can make the court reporter's job easier. And the reason why I try to make her job easier is because she has a very difficult job. She has to take down everything that everybody says. And if you can imagine, some of us want to whisper, some of us want to talk fast, some of us just do not want to talk. So if everyone can talk in the tone that I'm speaking at, with the same volume and at the pace that I'm speaking at, it will make her job so much easier today. So we're going to practice on trying to make her job easier. And I'm going to get you to make a commitment to me. Everyone, please raise your cards. All right. So when somebody asks, keep them raised until I ask you to lower them. When somebody asks you a question or there's something you want to say, you're going to raise your card. You're not going to say anything until the attorney says, for example, number 21, what would you like to say? Then you will be able to answer. I know it's difficult because sometimes we get into a conversation and we think we already know what the question is going to be, and we start speaking before the end of the question. Let's not do that. Is there anyone who's not going to be able to follow that rule? All right. Now, here's the other thing. Put your cards back up. This courtroom, the acoustics are horrible. So this is what I need from you. And I want you to follow this instruction. No jury has been able to follow this instruction. And we have jury trials in this court every week. So jurors 1 through 14, lower your cards. Number 15 through 21, lower your card. If you still have your card up, which means number 21, 22 through 65, your card is still up. What I'm going to need you to do when you're answering a question, I'm going to need you to stand when you answer that question. And if you see the person next to you not standing, tell them, let's not do this. The judge has faith that we're going to follow these instructions. So can all of you do that? Yes. All right, you can lower your card. Now, the parties have had a chance to introduce themselves to you. Raise your card if you recognize any of the parties that have introduced themselves to you. All right. Now, the next thing I want to talk to you, the charges in this case, what Ms. Rodriguez has been accused of is aggravated assault with a deadly weapon in count 1. And in count 2 is aggravated assault with a deadly weapon. Now, the attorneys are going to get a chance to speak with you and ask you questions. When they're talking to you, they are not allowed to tell you what they think the facts are in this case. The only time you will get a chance to know what anyone thinks the facts are in this case is if you are selected to be on the jury. So do not do a Mrs. Kravitz from Bewitch and say, oh, these are the facts in this case, because no one is allowed to tell you what they think the facts are. So when people are talking to you, everything is a hypothetical. Does everyone understand? Yes. You guys are whispering. Does everybody understand? Yes. Right. Now, the next thing I want to talk to you about is indictments. In felony courts, the way people come to felony courts for a jury trial is by way of indictment. An indictment is just a piece of paper, and you know what it's designed to do? To tell you what you're being accused of and where you need to appear if you want a jury trial. For example, raise your card if you've ever had a traffic ticket. Yeah, this group is one of the worst driving groups we've had here. So you can lower your car. I've had a traffic ticket before when I was about 18. And, I'm 21 now, so I've learned. So back in the day when I got my traffic ticket, that's when the officers had carbon copies. So they tear off a sheet of paper and give it to you. Well, on that sheet of paper, the officer will put on there what he thinks you did. Now they have certain boxes, but back in the day, they would write, speeding, ran stop sign, and that box would be checked. And then below it, it would tell you where you need to appear, either to pay the ticket or either go to a jury trial. Now, here in San Antonio, usually they send you to Frio Street. That's where municipal court is. So when you're accepting that ticket from that officer, you're not saying, you're right, I did this. You're just being put on notice that, hey, you need to appear in municipal court. This is what you're being accused of. And this is where, if you want a jury trial, you can have a jury trial. But it's not evidence of guilt. It's not evidence of anything. Does everyone understand?
Yes.
So an indictment is the same way. An indictment is not evidence or anything. It's just a piece of paper to let somebody know what they're accused of and where they need to come if they want a jury trial. Does everyone understand?
Yes.
So you are not allowed to consider the fact that Ms. Rodriguez is here under indictment. It's not evidence of anything. It's not for you to comment on at all. Does everyone understand? The indictment is really just a piece of paper to let anybody know who's accused. This is what you're being accused of. It would be bad if you get a traffic ticket and they say the officer is accusing you of running a stop sign. And then when you get to municipal court, you're like, I'm ready to go. I know I didn't run a stop sign. And all of a sudden, jury's seated. And then they say, well, we want to talk about her running this red light. And you'll be like, wait a minute, I'm here for a stop sign. What are they talking about? So it's the same thing with indictments. It's just to let the person who's accused know what they're being accused of and where they need to be if they want to have a jury trial. Does everyone understand?
Yeah.
Is there anyone here who's going to hold it against Ms. Rodriguez or consider it at all the fact that she's here under indictment? Raise your card if that's you. All right, the next thing I want to talk to you is certain rights that people have who are accused. One of the rights a person who's accused of a criminal offense has is the right to remain silent. What does that mean? That means that you do not have to testify. That means that the state can't say, the next witness we're going to call is going to be the accused. It's not allowed. That's our Constitution. That's the law. I've been a defense attorney. I've been a prosecutor. And let me just tell you, there are many reasons why someone who's accused of an offense may not testify. Sometimes, and I'll speak from my personal experience, sometimes my clients, they would be so nervous. And people always will ask you, how do you judge somebody's credibility? And what jurors used to say, oh, they're not looking me in the eye. Oh, they're nervous. Oh, they're sweating. Oh, they look to the left instead of to the right. Oh, they're stumbling over their words. That's what people would say. And sometimes I would have a client who would be so nervous and I would tell them, I'm fighting for you and you're nervous sitting in my office. You maybe would not be a good person to testify. So I'll let you know if you really need to testify, but maybe you won't. And sometimes I would tell a client, hey, the state didn't even prove their case. There's no need for you to testify. Sometimes people have speech impediments. Sometimes people are just afraid of public speaking. And believe it or not, people don't think of it, but when you're called to testify in front of strangers, that's public speaking. So the key to that is if Ms. Rodriguez does not testify, you cannot hold it against her. You cannot consider it for anything whatsoever. Does everyone understand?
Yeah.
Now, some people will say, and I always chuckle when I hear this, some jurors who've never been accused, who've never had to testify in any type of setting, they will always say, well, if that were me, I'd get on the stand and I'd testify. And I always chuckle because I'm like, yeah, but it's not you. And you don't have experts talking to you, right? You know, it's sort of like when you have a medical doctor and the medical doctor say, hey, here's your issue. You may go get a second opinion. And then the doctor will say, this is the treatment that you need to solve your issue. Now, you may say, well, I'm going to get another opinion on the treatment. But ultimately, you may decide to, you know what, this person is an expert. I'm not. This is what they're saying. I'm going to go with it. Sort of like when you have a vehicle and you take your vehicle in and the air conditioner is not working in the summertime, but it'll work in the winter, but not the summertime. You take it into the mechanic. The mechanic's like, your problem solved. And then the next thing you know, the transmission, and you continue taking it back to the same mechanic, but you go to them because they're experts and you're following their advice. So again, is there anyone here who's going to hold it against Ms. Rodriguez if she decides not to testify? All right. The next thing I want to talk to you about is burden of proof. In criminal cases, the state has to prove their case by proving each and every element beyond a reasonable doubt. Now, you're probably asking yourself, I've seen Perry Mason, I've seen the practice, but let me wait for the judge to give me a definition of beyond a reasonable doubt. When I was in law school, you had to know that definition. You had to know it forwards and backwards. I learned that definition. My first jury trial, I knew where to put the commas. I knew where to put the exclamation point. I knew where to pause for dramatic effect. And then after my first trial, the powers that be decided that there is no longer a definition for proof beyond a reasonable doubt. So neither the state's attorney nor the defense attorneys will be able to give you a definition of proof beyond a reasonable doubt because there is no definition for proof beyond a reasonable doubt. So I had to figure out, well, how can I explain this to the jury then? So next door, we have the civil court, the historic courthouse that you all should visit with the green rooftop. Over there, they handle civil cases, your car accidents, maybe insurance is involved, your custody issues, those type of cases. Over there, they have two burdens of proof. One is preponderance of the evidence. More likely than not, something happened. If you are ever on a criminal jury and you're deliberating and somebody starts saying, well, I believe more likely than not, you need to tell them, hey, remember, we're not at the historic courthouse that we should visit. We're on the criminal side and you are at the wrong burden of proof. So proof beyond a reasonable doubt is higher than preponderance of the evidence. So it's not more likely than not something happened. The other burden of proof they have over there is what's called clear and convincing evidence. Clear and convincing evidence is the evidence that the government uses to say, you are a danger to your child. Legally, you will no longer be allowed to parent a child, and we're going to take that child away from you. Now, you think to yourself, judge, yeah, that's a high burden. But guess what? That's the civil side's highest burden, but it's still not higher than proof beyond a reasonable doubt. Does everyone understand? Now, the next thing I want to talk to you about is fairness. Attorneys will always ask you sometime, can you be fair? Well, maybe this is a trial you really shouldn't be in because, you really can't be fair. The example they always will use sometimes is that you are coming downtown for jury duty and you have made plans, you mapped out your routes, you even did a test run so that you'll know where the construction sites are, even though when you drove down, there were new construction sites, but you have planned. And when you get up the next morning, your vehicle is on cinder blocks. Somebody has stolen your tires, they've broken into your vehicle, they've taken everything. But you want to do your civic duty. So you catch a via or either get your best friend or you take an Uber and you still make it downtown. And then you're standing outside waiting for jury selection and you find out it's a burglary of a vehicle. Usually people will say, you can't be fair in that case. Really, can you? Because this just happened. This is what fairness means in a criminal court. Fairness means no matter what has happened to you in your past, no matter what trauma you have suffered, are you able to sit and listen to the evidence that's presented to you? And if you can come to a decision, base your decision upon the evidence that you hear. Does everyone understand?
Yeah.
So that's all fairness means, because raise your card if you were born yesterday and slept all last night. So what does that mean? That means that everybody here is walking, talking. You're at least 18 years of age. So in your 18 years, all the way up to whoever the oldest person or most experienced person is in this group, you've had life experiences. You've had maybe some good things happen to you, maybe some bad things, maybe some middle of the road things to happen to you. But the real question about fairness is, if you are placed on this jury, will you be able to listen to the evidence? And if you can come to a decision, base your decision upon the evidence that you hear. Does everyone understand?
Yes.
Is there anyone here who cannot do that? Now, the next thing I want to talk to you about is phases of trial. There are 2 phases to every criminal trial. The first phase, people love to call it the innocence phase, but that's not really what it is. The first phase is simple. Did the state prove their case or did they not? And if the answer is they didn't prove their case beyond a reasonable doubt, then your verdict should be not guilty. If they prove their case beyond a reasonable doubt, each and every element, then your verdict should be guilty. That's really all the first phase is. It's not whether somebody's innocent. It's whether did the state prove each and every element of their case beyond a reasonable doubt. Does everyone understand?
Yeah.
Now, in Texas, there is a rule that in a law that when you are going to a jury trial, you have to make a decision on if you were found guilty, who would determine your punishment? Are you going to let the jury determine your punishment or the court? When somebody makes that election or selection, they're not saying they're guilty. The law just requires that they make a decision on if they were found guilty, who would decide punishment. Does everyone understand?
Yes.
So in this case, Ms. Rodriguez had to make an election or a selection or a decision on who would decide punishment if she were found guilty. In this case, she has decided if she were found guilty, the jury would decide what would be the appropriate punishment. Does everyone understand?
Yes.
Now, is there anyone here who will say for religious reason, and I'm going to ask you to quote the Bible verse to me, for religious reasons or some other reason, you can't sit in judgment of someone? All right. So now the next thing I want to talk to you about is punishment. What is that? In Texas, criminal charges have ranges of punishment that the legislature has decided this is.
The new bearskin.
All right. And are you Mr. Beltran?
Yes, Your Honor.
All right. In defense, you said you've adopted his motions?
Yes, Your Honor.
All right. So the first motion is a motion for a special appearance under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue that the court does not have in persona or subject matter jurisdiction.
All right. Is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction
to preside over any matters. The defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Dare County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to happen in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand?
Mm-hmm.
All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of in the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, and it has to be allegations that it happened in Bexar County, and it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bexar County, then it would come to a felony district court, state district court that's in Bexar County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you. And then we have,
Did
Yes.
the court take judicial notice of the indictment in this case?
yes,
Make its ruling, okay.
yes.
The
The next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph, that the court his position was the court didn't have jurisdiction. The court just ruled that they did. That then the indictment would not be valid in this case. So I think that's what the client is trying to say.
All right.
Did I get that right?
Yes.
Okay.
All right. So State, you want to address the issue and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right. So if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right. So Mr. Beltran, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code, and there's a list in the penal code of all the crimes, and aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of that. Now,
My energy bill dropped from $150 to $50.
you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So, do you understand? You gonna have any questions about the court's ruling? All right. If there's something you don't understand, let me know. All right. And I understand that sometimes when people have been to law school, like for example, I haven't really worked on cars, so there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right. So number 3, defendant is erroneously charged with an abstract offense. C, I don't know, I can't read that word. Something taxation. A district court is criminally attempting to receive an unauthorized, colorable, no fault immunity third-party benefit in violation of the 7th Amendment. All right, do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to, being a third party brought in here without, abstract subject matter jurisdiction. And, the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right, State, do you want to respond?
Judge, reverting, I guess, the 7th Amendment applying in the case, or, okay,
Yes.
that is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
Mhm. All right, so the 7th Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial. And if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say, explain it to me. You're saying district court is criminally attempting to receive an unauthorized, colorable, no fault immunity. What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand?
Yes, ma'am.
Do you have any question about that?
No, ma'am.
All right. So then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 USCS 841. This court now under federal questioning under Title 28 USC 1331, light of new evidence investigation hypothetical claims. All right, defense.
I'm not sure what my client means by that. I'm going to ask him to explain it.
All right, if you could explain that to me, Mr. Beltran.
Here's what I'm trying to say there, Your Honor, is how the state of Texas is plaintiff, and they're the ones that are pursuing me to prosecute me, which is they're the one of third party.
Okay.
And I'm not. Well, I don't. Third party, I'm not sure how that works. I know how civil suits, and I know it's criminal law, but I know that. I mean, how can I cross-examine the state of Texas? How can I?
So let me explain something to you. whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual. If it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bexar. So that's why the state of Texas is listed and not the complainant. Do you understand?
Yes, I understand that. And so how do I cross-examine the state of Texas?
The state of Texas, you don't cross-examine them. The persons you would cross-examine would be any witnesses the state of Texas would call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bexar County. They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You understand?
I understand.
All right. Do you have any questions or any confusion? All right.
May I ask my client a question before you go on to next? Are there any other things in here? Because some of it repeats itself. Were those the main points?
Those are the main points.
Or is there anything else in your motion that are different that we need to bring to the court's attention that would be different?
All right. So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls. Okay?
Understood.
So that will be denied.
There is it appears to me that there was like 3 separate documents stapled together. Is that the way it was received?
Yes.
There is the next one, which is exhausting administrative relief.
Mm-hmm.
My client is not wanting to have that heard, right? It deals with ineffective assistance of counsel.
Mm-hmm.
Right, Mr. Beltran, that's not to be heard right now? Okay.
All right. And let me explain something to you. I understand that's not to be heard right now, but what I can tell you is attorneys who are appointed to represent people, those are attorneys who are on the wheel for appointments, right? And if this is a first-degree felony, just from the face of what I'm looking at, and if Ms. Gay wasn't qualified according to the qualifications to be on the wheel for first-degree felonies, she would not have been appointed to represent you. Do you understand?
Understood.
And Ms. Gay, are you on the first-degree will?
Yes, I am.
All right.
So the next document is entitled Court Constitutional Notice.
Mm-hmm.
And that addresses antitrust violations, fraud upon the court, actions of the state bar.
All right. Do you want to take these one at a time, counsel?
I guess so, Your Honor.
All right. The first is new discovery of antitrust violation lies fraud upon the court, elected state bar officials, seditious organization are conspiring to fraudulently conceal the ultimate fact, Sixth Amendment misconduct, that the State Bar of Texas lacks capacity to prosecute a natural person. It is an improper plaintiff. All right, so with that, I can tell you the State Bar of Texas is not prosecuting you. The State Bar of Texas is more of an affiliation that attorneys are required to belong to. And we actually have to pay state bar dues every year. And when that comes around every year, everybody's like, oh my gosh, state bar dues.
Student.
Yes. So the state bar is not participating in this trial. Now,
while everyone else wastes money on expensive Mylar.
your client, your attorney as an attorney, and the state as an attorney, anyone who's licensed in Texas, they're required to be a member of the State Bar of Texas, and they have to pay dues to the State Bar of Texas. I think it's $265. It may have gone up. All right, so they're not going to be trying you.
Yes, sir.
All right, the next one is State Bar's virtually gathered evidence, video, police reports, third party. Again, what I can tell you about that is the State Bar hasn't gathered any evidence. State.
I think I just put, I'm sorry, Your Honor.
Yes.
I think I just put that as.
All right, so do you want that heard or no? All right, and then the next one is, so to permanently prevent a false State Bar, anything with regards to the State Bar, do you still want that heard or no? It says, objects to Texas State Bar ex parte matter waivers and fictional double jeopardy defective jurisdiction. Do you want that heard?
Yes.
All right. Defense?
My client believes that, again, that the court does not have jurisdiction, that he is concerned about his waiver of his constitutional rights. Some of this deals with what happens at trial, like hearsay evidence being admissible, being admitted wrongfully, and that he still believes he's a third party, and that there's abstract jurisdiction, and that the court doesn't have the power, I'm guessing, to rule on evidentiary issues such as 901, and that, in other words, probable cause is third party fabricated, then secretly planted and dressed up to appear that it has merit, but it does not. So he is talking about one jurisdiction and also trying to state his right to object to evidence.
All right, State, do you want to address that?
Regarding the selection of evidence, I'm not sure.
Oh, no. So, let's address double jeopardy. Double jeopardy, defective jurisdiction. So double jeopardy, if you have not been previously tried for this same offense before, that's what double jeopardy is. Basically, in a nutshell, there are certain exceptions to that. But when you mention double jeopardy is you've been tried for something before and you were found not guilty, right? And now the state is trying to try you for the same thing, even though you were previously found not guilty of it. Or either you had something that was dismissed with prejudice and they're coming back and trying to try you for that same offense. Do you understand?
Yes, ma'am.
State, has he been tried before for this same offense?
No, Judge, there has been no actions on the indictment or the indictments that are pending against him. And as far as I know, he's not been charged by any other jurisdiction regarding this offense.
And there has never been anything pre-indictment that was dismissed with prejudice with regards to these cases? All right. Does that address that issue for you?
Yes, ma'am.
All right. Then the next one, deceitful corporate veil and trumped up judiciary immunity is fatally pierced. I do not forfeit my privileges and immunities under the 4th and 14th Amendment. What I can tell you is during a jury trial, when the state calls their witnesses, your attorney will have a chance to cross-examine those witnesses. The rules of evidence do apply. If she finds that there is some question that is objectionable and should not be answered, then she will stand up, make an objection. Normally, the objections may be hearsay, entering the province of the jury, assuming facts not in evidence. It could be relevancy. It could be 404B. It could be any of a number of objections that she can make. Once she makes those objections, I will make a ruling, and my ruling will decide whether or not the witness can answer that question and whether or not the jury can consider it. Do you understand?
Yes, sir.
All right. Does that address that issue?
Yes, sir.
I think the other issues deal on the second page, deal with the state bar, and I think the courts address that.
Okay.
The other one is the gross advertising negligence of the DA's office.
Okay.
And defendant being sued,
Oh, who's being sued?
the defendant.
All right. So, sir, there are different type of suits. There are civil suits. So technically somebody can be sued civilly for something. Sometimes with criminal cases, people will say, oh, it's a suit. Technically it is sort of a suit, but it's again, the state of Texas versus whoever the defendant is. You understand?
Yes, sir.
All right. Do you have any questions about anything else? Okay. And then the next page, page 6, it has postscript. Is there something in there that needs to be addressed? I think it says here, it has to do with cross-examination. And then he say the plaintiff is in harmless artificial corporation. Are you talking about yourself or the state of Texas? Okay. All right. So whether or not it's a fishing expedition or corporate entrapment or a Ponzi scheme, that'll be something that will be decided during the jury trial. Okay.
Yes, ma'am.
All right. All right. Is there any other motion that needs to be heard?
Anything else? Any other jurisdictional arguments that raised that we have not talked about and the judge has already ruled? Anything other than
No.
All right. Is there anything that you don't understand about the jury trial process? All right. So I will still give you a choice. If you want a jury trial, you can have a jury trial. If you want a bench trial, if the state agrees to the bench trial, then we can have a bench trial. As I've told you before, if the state presents evidence that proves you guilty beyond a reasonable doubt, that means each and every element, I'll find you guilty. If they don't, I'm going to find you not guilty. You understand?
Yes, sir.
All right. So if you still want a jury trial, you're, Norma, is he already scheduled for jury trial?
Not scheduled for yesterday, Judge.
All right. So, counsel, you're still requesting a jury trial? All right. Norma, if you can put them on the jury trial, please. And Ms. Galloway, if you confer with the defense on a jury trial date. So they're going to get a jury trial date, okay?
Thank you, Your Honor.
Oh, you're welcome.
Never do these
that he picked up his son. The car was okay. He wasn't a part of burning in the fire, wasn't a part of the co-defendants. It wasn't a plan of his. He had nothing to do with it. He's just there. He picks up his son. When he picks up his son, the car is not on fire and he leaves.
This is a case about a man charged with a shocking act of arson. He had a deal with the state that would have allowed him to get off with just probation. But everything changed when the judge read the police report, which showed that he had blamed the whole situation on his own son, rather than simply...
Austin South and State.
For the Parkville Mayor, Mr. Rodriguez, Your Honor, present on bond, ready?
And are you Henry Rodriguez?
Yes, ma'am.
All right, did you review the document entitled, I'm sorry, counsel, have you reviewed all discovery with your client? Did you understand it? I'm sorry, did you review all the discovery with your client?
Yes, Your Honor.
And have you received all discovery?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Rodriguez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Okay, so it looks like a standard plea deal to keep him out of prison, but listen closely because the judge is about to mention a condition about his job that you almost never hear in courtroom.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, are you proceeding on the indictment as presented?
We're proceeding on the last paragraph, Your Honor, and waiving the remaining paragraphs.
Any objection to the waivers?
No objection, Your Honor.
And any objection to the waiver of the reading of the indictment?
None, Your Honor.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, you're gonna have to answer yes or no.
Yes, Your Honor.
All right, you're charged with the offense of arson as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is, he was, Your Honor.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Most definitely. Yes, ma'am. Yes,
If you're not a U.S. citizen, by entering into this plea, you will be deported, not allowed re-entry, and denied naturalization. Did you understand?
yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,500 fine. State recommends deferred adjudication. It states you will not accept or maintain employment in the insurance industry or any other position which involves in whole or in part the handling of insurance sales, appraisals, claims, or other transactions. And you will surrender your insurance license with the Texas Department of Insurance prior to entering any plea in this case. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes, Your Honor. He has surrendered, Your Honor, for purpose of the record, license pursuant to the agreement.
Giving up your entire career is a huge step, so he clearly wants this deal. That makes what the judge does next so surprising. She's about to ask a simple question that has nothing to do with the plea, and it could change everything.
Yes, ma'am.
Right. And the court has in the paperwork a voluntary surrender of insurance licensing.
Sure.
And is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
Filed, Your Honor, but not.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 10 years. There be a TAP evaluation, 200 hours of community service restitution, the fire safety anti-arson class, and MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
To the offenses charged in the last paragraph, how do you plead? Guilty, not guilty, or no contest? State any evidence.
It offers State's Exhibit 1 and all attachments.
We reviewed it in our expensive.
Right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
1 minute, 37 seconds later.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I've reviewed extensively with my client. My client is gainfully employed, Your Honor. He and his wife own a very successful roofing business. He consulted long and hard about the situation and facts. Asked the court to follow a plea agreement, Your Honor. Only request, perhaps, Your Honor, that you mitigate half, perhaps, of his community service as he works about 50 hours a week, Judge. And we'd be happy to pay that to charity.
Okay. So, Mr. Rodriguez, why are you burning cars?
You can tell he was not expecting that question. The defendant has no idea what to say, but the judge does. She has his police report. She's about to read the part he was hoping everyone would forget.
Yeah.
Birmingham homeowners, did you know there are 8 different ways to sell your home? Most real estate agents, even though I love them, will only tell you the options that serve them best. If you
Not burning carbon.
Well, you burned this vehicle. Here's the thing. Do you want a jury trial? All right. So what I'm reading in this is you are part of this plan, I'm assuming, to defraud the insurance company, which means that when a vehicle is burned, for some reason, the insurance company then raises everybody else's rates, not just yours, everybody's. So according to this, you are part of this. And then when they interviewed you, what do? You blame it on your son.
There's 4 parties in the case, all charged separately. The wife charged now as well, Your Honor, for fraud. The son is before the court and with other counsel.
Yeah.
So, I mean, the facts in this case involve parties. Participation, intention, and what happened, Your Honor, are still somewhat included. But in this particular case,
Well, no, I mean, according to this, they say they interviewed him. At the conclusion of the interview, Henry B. Rodriguez, that's you, claims that the idea to set the car on fire was your son's. Henry Rodriguez and his ex-wife, Cynthia Medina you said it was your son's idea, Henry Medina Rodriguez's, and his ex-wife, Cynthia Medina Rodriguez. You just happened to be on that road to pick up your son, and you ended up leaving and the car was not on fire. That's what it says in here.
When I picked him.
There it is. He blamed his own son. His lawyer immediately tries to jump in and save the situation, but you have to wonder if the damage is already done. At this point, the judge could just throw the whole deal out.
So do you want a jury trial?
No, no, I swear this.
Your Honor,
No,
He's saying he wasn't a part of this.
but and
He's saying that he picked up his son, the car was okay. He wasn't a part of burning in the fire, wasn't a part of the co-defendants. It wasn't a plan of his. He had nothing to do with it. He's just there. He picks up his son. When he picks up his son, the car is not on fire and he leaves.
Well, as your Honor referenced State Exhibit 1, I mean, he stipulated that that's true and correct. And so that's the state's position as well.
You know, people always say when a crime is committed, you can't trust the people you're with, the co-defendants. I don't think they ever thought that the father would say, oh, no, it was my son's idea. I wasn't a part of it.
I'm sure they haven't thought, Your Honor, that he needed to be involved in it. You want to take that position, Judge. But at this point in time, assessing risk, assessing the facts, assessing the case, Your Honor, client is elected at this time.
All right. There's a $2,500 fine, regular reporting by Zoom or in person. You're not allowed to hold any type of employment in the insurance industry. That includes Texas and throughout the United States and overseas if they allow that. 10 years deferred adjudication. There's going to be a top evaluation. You can do that out of custody. 200 hours of community service restitution, and you will do those community service hours restitution. There's to be field visits 1 time per month for 6 months. I don't know, is there a reason for a request for the fire safety course? Because he started a fire, he knows how to start a fire. So does he really need the safety course if you're committing arson? I think everybody knows if you commit an arson, this is what's going to happen.
The paragraph you pled to was related to the surrounding conditions. There was a rural part of the county where there was a drought. And I think part of that class teaches them about some of those dangers. Maybe he's not aware of, I'm not sure, but it's still up to the court. So I put it under the line.
Mr. Rodriguez, if there's a drought and you start a fire, light firecrackers, guess what's going to end up happening? It's not a controlled burn. It's probably going to end up burning a lot of property. You're going to do the anti-arson course and the MRT. Probation, is there anything else?
You may.
Yes.
Submit employment.
Thank you. Regular random UAs. Proof of employment within 30 days. No employment as a home health care provider or with minors. Anything else?
Nothing on this in there.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
And that's it. The deal is locked in for good. He can't appeal, he can't fight it, the case is closed, but it still makes you think about the one person who wasn't in the room, the son who was blamed for it all.
All right, good luck to you.
And for purposes of the record, Your Honor, just to clear up one point, I may have missed it the way it was stated. It's his ex-wife here. And who would have thought the ex-wife would have said that her son sold a car so it could burn, that he could set it on fire? That's an interesting question.
Well, I mean, the interesting question is, why are parents doing this when they're supposed to be setting examples for children?
Well, appreciate both positions, Your Honor. I just
And then if you're involved in criminal activity, why are parents turning on their children? We don't know the answers to these questions, but one day we will figure it out.
Thank you, Your Honor.
Thank you.
Thank you, Judge. Thank you, Your Honor.
Ultimately, the judge accepted the plea and sentenced Henry Rodriguez to 10 years of deferred adjudication. While the defendant got the outcome he desired, he was initially compelled to confront his previous statement, where he had shifted the blame for the crime onto his son. This case stands out as a strong illustration of a judge exercising her authority to make sure that a plea is more than just a procedural step. It's a real acceptance of accountability. Even though the attorneys had a deal, the judge prioritized the integrity of the court.
Well, that's it for today, ladies and gentlemen. That is it for today. Tomorrow is Judge Middleton. Guys, if you like the content that's on this channel and you're not a subscriber to this channel, do me a big, huge favor. Subscribe to this channel and help this channel grow. But that's it for me. You all have a wonderful evening. Ta-ta and ciao, and I will see you guys tomorrow.
Breakdown, you're the one I call. From the mountains high, come down to it all. With your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all. solid ground, ground, always drawing near. Never give up on this heart of mine. Put it back together every single time.